Hello, dear students from all Egypt schools. Welcome to today's session. With you today, Ms. Wafaa Hassoub, and today, inshallah, we will continue programming and artificial intelligence and introduction to information and communication technology for first year of secondary school 2025-2026. And today, inshallah, we will take chapter 2, Laws and Rights in the Information Society. We will continue for chapter 2, lesson 2, intellectual property rights. Intellectual property rights. So, what's intellectual property rights is? These are the rights that protect creations and ideas generated by human intellectual activities. So, these rights are mainly divided into industrial property rights and copyrights. So, those rights are the rights that protect any creation you do, any ideas generated from you. And it's divided into two parts or two kinds of rights: industrial property rights and copyrights. You want more illustration? Follow me, please. Well, it means a special rule that protects things made by people's minds, like stories, games, and inventions. And as for the copyright, it's the most common right protecting artists and writers. Well, IPR, or the intellectual property rights. This is the abbreviation of it. Intellectual property rights. IPR. Well, are like special rules or rights that protect the creations and clever ideas that people make. They make sure that the creator gets credit and can control how their work is used. So by these rights, you can control what would you do or want to do with your creation, what you created. Think of your brilliant ideas as treasures you create. So intellectual property rights are the official rules that say this is your treasure and no one else can take it or copy it without your permission. So it keeps your rights and prevents others from taking or stealing your things, your creations. And there are two main treasures chests. As we already told you, we have two kinds of rights. The industrial property rights, which means rights primarily related to the manufacturing of industrial or commercial products. So, if you are publishing or you want to make an announcement about a product, you need to save and you need to protect your rights about this. So, we call this industrial property rights. So these rights protect things you invent or design, you create. Well, how it works? You have to tell the government about your invention to get a certificate that says it's officially yours. So, if you have an invention or you created something that's unique for all mankind, and you want to prove this is yours, you need to go to the government. You can't just tell people this creation is mine. No, you can't do this. You have to make it officially to prevent other people from stealing it. So you need to go to the government and tell them about your invention. If it's really yours, well, they will give you a certificate that prove that this is officially yours. Well, this followed the principle in which rights come into effect once an application is filed with and registered by the Egypt Patent Office. This is known as the formality principle. Formality principle. So the formality principle is what? It's about an application you fill just and register by the Egypt Patent Office and to prove that this is officially yours. Well, these protect things used in making products like new inventions, designs of cars, or product logos. To get these rights, you must fill an application. So to get the rights of these things you create, you need to get these rights. Well, how? By filling an application and have it registered by an office like the Egypt Patent Office. Well, that's what we call the formality principle. Formality principle. Well, types of that are patent rights. Patent rights. These are the rights to advanced technological ideas and inventions. It protects a brand new invention and it protects big new inventions like a super smart robot. So patent rights are rights for advanced technological ideas and inventions. For example, you invent a pencil that never needs sharpening. A patent stops other kids from making and selling the exact same pencil because it's yours. It's your invention. No one can steal it. No one can sell it without your permission. So this is the patent rights. Well, protection period for the patent rights, 20 years from the application. So this is the period for protection. Well, this is as for the patent rights. Well, now we have utility model rights. Utility model rights. What are they? These are rights to the shape or structure of a product. It protects a new shape or structure that makes a product work better. So if you created new shape or new structure, you need to have or need to fill an application of the utility model rights to protect your invention. For example, you design a new lunchbox with a special compartment that keeps juice cold and sandwiches warm. This right protects that clever structure. So you created a new lunchbox to stop others from selling or buying it without your permission. You need to have the utility model rights. So, and the protection period for the utility model rights are 7 years from the application when you apply. So you can invent it for 10 years. But you registered through the utility model right about 3 years ago. So protection period is 7 years from the application itself, when you fill the application, not from the time you invent it. And now for the design rights. Design rights, what are they? These are rights to a design, such as the shape and patterns of a product. It protects how something looks, like a cool phone case design. So this is not the shape or the structure, but the design you do in it. You fill it with glitter, you put smiley faces, you put cats, you design with dots and so on. So these rights protect the design you do in your creation. For example, you design a sneaker with glowing strips and a unique swirly pattern. Well, this is your creation. Well, the design rights protects that cool look. So no one can copy your design. No one can take this design of your sneakers, okay, and wear it without your permission. They have to go to you and ask your permission before they can copy it or sell it or buy it and so on. So the protection period for the design rights are 10 years from the application and to be renewed once every 5 years. And remember these information because they are pretty important for you. And now for the trademark rights. And I think many of you have seen it on bottles and so on. Trademark rights. So these are the rights related to items such as product names, logos, or text and sound. So when you create a name for your website, your application, your music, and so on, we call this trademark rights. It protects a name, logo, or sound that represents a brand. For example, the Golden Ox M for McDonald's. I think you have seen it before. M for McDonald's. Or the swoosh for Nike. This right means no other restaurants can use the M logo. Or any other shoes can take the right mark of Nike. We call these rights trademark rights. Trademark rights. And the protection period for it is 10 years from the registrations, and of course, it's updated. And now for the most famous one among all the rights, it's a copyright for creative works. So we have now the copyrights for creative works. These are rights related to creative activities in the arts and cover works such as novels, movies, paintings, photographs, music, and computer programs. So anything you create related to all of these, you need to protect your creation. You have to search for the copyrights for it. Novels, movies, paintings, photographs, music, and computer programs. When an artist draws a beautiful painting, a writer writes a wonderful story, that work belongs to the copyright. So, copyright laws protects this work and make its owner the only one who decides how others can use it. So, if you created a novel, no one else can sell it or buy it without your permission because you have copyright to it. So they can't make copies from it. An example for it, dear students, if you draw a beautiful picture, no one else had the right to copy it and say it's theirs or sell it without your permission. So that's what we call copyright. Because if he violated this, he may go into jail. And you can sue them, sue, ask them for prison or go to the judge, go to the court. So they have to ask your permission before they can copy it or sell it or buy it or so on. So this way it followed the non-formality principle. Non-formality principle, and remember it very well. It's the non-formality principle under which rights are established at the moment a copyrighted work is created, regardless of whether the creator is an amateur or a minor. So, no matter your age is, if you're a child, a teenage, an old man, or a youth, or whatever, it's not due to age. Just whenever you create something, okay, so this is a non-formality principle. So your rights are established the moment you, okay, your work is created. The moment you create your work, so you have non-formality principle rights for that. Well, how it works, the moment you finish your creating or your creation, you automatically own the copyright. You don't need a certificate. So this is the non-formality principle. Once you created something, you have the right to it. No one else can violate this right unless he come back to you and ask your permission. This is the non-formality principle, okay? The moment you finish creating something, you automatically own the copyright for it. You don't need a certificate for it. Well, as for the copyright infringement, well, as a general rule, when reproducing something else copyrighted work or using it on a website, it's necessary to obtain permission from the creator. So this is the copyright infringement. You need to get a permission for any other product or any other creation before copywriting it. You need to get the permission for it. Well, using a work without permission would constitute a copyright infringement. So please be careful before you take a photo, you take a movie or a novel and sell it or use it. You may go into jail. So be careful, please. Well, this is a fancy word for stealing someone's creative work. Well, as an example for it, if you download the movie Frozen from an illegal website instead of paying for it, well, now you are stealing the work of the artists and the animators. That's copyright infringement. So the copyright infringement means violating the rule, okay, or stealing something without your permission. This is the copyright infringement. Okay. Again, if you have, and I think some of you do it, if you want to use a full utility or full options of an application or a platform, you search for the product key. How can you steal the product key without paying? And this is copyright infringement. This is stealing. Okay? And they can sue you for what you do. So be careful, please. Well, Copyright Act. What is a Copyright Act? It's a law that protects the rights of creators. So a Copyright Act is a law that protects the rights of creators. And the copyright protection period for your whole life plus 50 years after you pass away. Pass away means to die, okay? So for your whole life, you have a copyright protection. If you pass away, if you die, okay, you have 50 years more. But after 50 years, after your death, okay, is go public, free for everyone to use. Okay, we call it open source or free to use. So be careful and listen carefully. The copyright protection period is all your life, whole life of yours, okay? And 50 years more after your death or after one's death. After these 50 years pass, you everyone have the right to use it, okay? So after that, it becomes public domain and anyone can use it, as we told you. Moral rights of creator. we have the moral rights of creators. So they are rights that protect the personal interests of the creator. So we call them moral rights of creator. Well, now we have copyright property rights. Okay, property rights. So what are property rights? These are rights that protect the economic interests of the creator financially. Because we create an application, we create games. As we know here, we have our platform, Choreo. They're going to teach you, and we are going to teach you how to create application, games, websites, and so on. Why? Because we want you to gain money from it, to gain, of course, experience and gain money. So how can you protect your financial property? By property rights. Property rights, okay? So now we have neighboring rights. Neighboring rights, well, they are rights that rise for individuals or entities who communicate or transmit copyrights work. So if you transmitted your rights of a work to someone else, we call it neighboring rights. Okay? So these are granted to performers such as singers, directors, and actors, as well as record companies and broadcasting organizations. And of course, these are the important copyrights made simple. We have copyright and public domain, Creative Commons, and Creative Commons for it. So we want you to know your rights and try to protect them when you create anything. Well, what's the difference between formality principle vs non-formality principle? Do you remember the formality principle and non-formality principle? Well, we are going to show you the difference between both of them. Well, if you have to fill an application and get a certificate, so we call it the formality principle. So, formality principle, you have to go to the government, file an application, get a certificate for your rights. That we call formality principle. But the non-formality principle is you have the right of your creation once you create it. So you don't go to the government, you don't fill an application or anything else. No, once you create it, you have the rights for it. So this is the non-formality principle. It's under which rights are established at the moment the copyright work is created. So once you created it, okay, it's not formality principle. You have the right for it. No matter your age is, a minor or an old person or a mature. And now this is question 4. So try to think carefully about each question, please. Do it with us. Well, answer the following questions. Insert the appropriate term for 1 to 6 to complete the following sentence. Well, the rights granted to a creator when they produce something through intellectual activities are called intellectual property rights. Intellectual property rights. Well, these are primarily composed of industrial property rights, which contribute to the development of industry. And number 2, do you remember? Copyrights, of course, which contribute to the development of culture. And second, we have Egypt Patent Office. Egypt Patent Office, okay? It's gonna be number 4, but here, yes, it's are established under the Egypt Patent Office. We have number 5. Yes, it's formality principle in which rights are granted upon approval after filing a notification with, as we told you, if you're going to fill a notification or fill an application, it's formality principle. It's the formality principle. So this is number 5. Formality principle in which rights are granted upon approval after filing a notification with, of course, the Egypt Patent Office. On the other hand, okay, copyrights don't require reporting or registrations, and the rights are granted at the time of creation. Furthermore, the protection period for the copyrights is, of course, 50 years after the death of the creator. So it's 50 years, as we told you, after his death, whoever who is. Still with the questions. For the following statements concerning the laws and rights of information society, mark O if the statement is appropriate and X if it's incorrect. Well, posting Taha Hussein's novel The Days on your website without permission doesn't constitute copyright infringement. Is that right? We will see it together and give you the reason for it. Downloading music or videos that are for sale while knowing that they have been illegally uploaded constitutes copyright infringement? Well, we will see it together. 3. Posting the audio data of Beethoven's Symphony Number 5, Fate, played exceptionally well by someone else on social media doesn't constitute copyright infringement? You think is it false or true? And finally, we have number 4, trademark rights conclude 10 years after registration with the patent office, but the rights can be maintained through renewal procedures. Well, the correct answer is gonna be, as for Taha Hussein's novel, The Days, novelists like Taha Hussein can be used copyright-free. Why? Because over 50 years have passed since their death. So you can use whatever Taha Hussein created before because he passed away and more than 50 years passed over his death. So you can use his creation for free now. And as for number 2, downloading music or movies while knowing they have been illegally uploaded constitutes copyright infringement. Therefore, well, this is a violation for the copyright and it's considered copyright infringement. Okay? Because it's illegally uploaded. So you can go to jail because of it. Number 3, musical compositions by Beethoven, Mozart, and similar composers are no longer under copyright protection because more than 50 years have passed since their death, like Taha Hussein. However, performers and record companies have neighboring rights, so it's necessary to verify the user's permission, therefore. So we told you before about the neighboring rights. What are the neighboring rights? If a creator passed away, died, okay, maybe someone is responsible for his creations, like companies or like some relatives or so on. So if there are neighboring rights, you can't take it for free. You have to take their permission. Okay? So performance and record companies have neighboring rights. So it's necessary to verify the usage permissions. So this is wrong, of course. And as for number 4, trademark rights conclude 10 years after registration with the patent office, but the rights can be maintained for an additional 10 years through renewal procedures. So you have 10 years after registration and 10 years more after renewal procedures. So you can renew it for more 10 years. Question after that, answer the following questions. Among intellectual property rights, what's the term for the rights that pertain to the manufacturing of industrial and manufactured products? We call it, if you remember, design rights. Design rights. Well, what the term for rights that protect the marks used to distinguish goods and services. Goods and services. Goods here doesn't mean something is good or bad. No, goods here means the products itself. So products and services. So what is the term for the rights that protect the marks used to distinguish goods and services? We call it trademark rights. Trademark rights. And what is the term for the rights that protect inventions of things or methods? We call it patent rights. Patent rights. Read the following passage and answer the question. There are 4 types of industrial property rights: patent rights, utility model rights, design rights, and rights. Among these utility model rights are rights pertaining to, and additionally, rights refers to the rights concerning products, names, or logos, and the protection period is years from the date of registrations. Well, and the answers for him, of course, for the first A, we need to fill it, the blank with appropriate term. So it's a trademark. It's a trademark. And question 2, answer by filling in blank B with the appropriate number. So we need here 10. The trademark rights are typically granted for 10 years periods and can be renewed. And as for number 3, choose the most appropriate phrase to fill in blank from the options A to D below and answer using the letters. Well, it's of course letter D. And finally, for the question, utility model rights are often referred to as PT patents and protect the ideas for the structure and shape of a product that create a technical function or utility. So this is the final for the question of today. Hope you, inshallah, got all the information in a correct way. Goodbye.